afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our September 20th, 2018 public meeting, and welcome back everyone from the summer. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversions of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks and the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board's rules. We first turn to a vote of the minutes from the July 19, 2018 public meeting. Are there any corrections or comments to the minutes? If there are no comments or...
The minutes indicate on page 4, bottom of page 4, PowerPoint presentation is attached, but
Is attached.
it was maybe attached to something, but it wasn't attached to the minutes I received.
Oh, it's the PowerPoint presentation that Ms. Liddell.
Oh, I was clear what it was,
Yeah.
but the minutes seem to imply that it's attached to the minutes.
Well, it will be on the website. Do you want it?
Do I want a copy of the PowerPoint?
Yeah.
Yeah, I would say if you send out minutes that say something's attached,
Okay.
that's part of the minutes, that it would be prudent to send it.
Well, either that or the word is should change the was.
No, well, it's...
No,
No,
it
Or will be.
just gonna make it longer, right?
The only other comment I would make is I thought the way the minutes are currently being written is very helpful, very clear.
Thank you. I'll pass it along to our...
Sorry.
Great job. Thank you.
Terry Ryan, our new reservist,
Ah.
is doing the minutes.
They're great minutes. Thank you.
Are there any additional comments or questions regarding corrections to the minutes? Then if there's none, then may I have a motion then to accept the minutes? Mr. Roche and Mr. Delaney will second. Mr. Rivera.
Mr. Carter.
Yes.
Mr. Barber.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Abstain.
Mr. Delaney.
Yes.
Mr. Shachter.
Abstain.
Ms. Torres.
Yes.
Chairperson Hudson.
Yes.
Six in favor, 2 abstain.
We are bypassing, on the agenda we had a resolution for Chiefs by the 4. We are going to bypass that until next month's meeting out of respect for the next applicant who wants to be here to accept it. So we will then, because of a board member who has to leave due to a family matter, we're changing the order of the agenda. We have to vote on the cases first and then handle the other matters on the agenda afterwards. So we then now turn to vote on the cases. The first, we start with the appeals and reconsideration calendar. There are 4 cases on that calendar. The first one is Ty Lloyd at 324 Canal Street in Manhattan, docket number AD0091. Mr. Clark, please present this case.
Thank you, Chairperson Hilton, board members. Excuse me. On November 2nd, 2016, the owner of the building filed a registration application for 5 units, including units on the 2nd and 3rd floors. In the registration application, owner certified that units 2 and 3 were then vacant, but a former tenant occupied the units during the window period. Owner also submitted a sworn affidavit that from the building's handyman stating units 2 and 3 were residentially occupied during the entire window period. On March 13th, 2017, the Loft Board accepted the registration of the building and registered units 2 and 3 among others. On May 30th, 2017, owner filed sales records forms for units 2 and 3, which stated the sales took place on May 2nd, 2017, after the former window period tenant vacated the units. On August 11th, 2017, the Loft Board Executive Director issued an administrative determination rejecting the purported sales pursuant to Section 2-10A1 because the former tenant was not a residential occupant of the units at the time of the purported sales and denied owner's request to deregister the units. On September 25th, 2017, owner filed an appeal challenging the determination. Owner first argues it was an error of law to reject the sales of the units because a tenant need not be a residential occupant to effectuate a valid sale of rights. Owner cites to Section 2-10F48, which provides that when deciding abandonment cases, the Loft Board should consider whether the owner made affirmative efforts to locate the occupant to attempt to purchase Article 7C rights. However, Section 210F4 only applies to abandonment cases. Here, owner did not file an abandonment application for the units, and therefore, Section 210F4 is not applicable. Owner also argues the court found that the estate of the protected tenant and not the actual residential occupant was entitled to compensation for improvements after the death of the protected occupant. However, the court's expansion of the meaning of residential occupant to include a residential occupant's estate after the death of the tenant does not mean the board should further expand that meaning. Finally, owner argues the units should be deregistered because the affidavit filed by the owner was insufficient proof to establish residency. However, based on owner's certification and the affidavit provided, the Loft Board staff's assignment of an IMD registration for the units was proper. For the reasons stated, the proposed order before you today denies the appeal.
Thank you, Mr. Clark. Is there a motion, or excuse me, do you have comments on this case?
Yes, I can't vote on this case because I actually know one of the parties mentioned in the opinion.
Thank you.
Yes, I would just comment briefly that this is yet again another very creative attempt on the part of the argument being made by the owner to try to expand what's going to be viewed as a 286-12 sale of rights. And this is an area where we have seen a variety of different problems crop up in the past year or two. And I think it is important for the Loft Board to consider revisiting 286-12 to tighten up and clarify exactly what does constitute a sale of rights under 286-12. This has become an area of considerable abuse, and I made the statement to the board staff in the private meeting and want to just go on record with it in public. I've even heard examples now of cases where the lease, which an owner offers an incoming tenant, includes as one of the terms of the lease a 286-12 sale. We've also seen in the past documented case where an owner tried to incorporate 286-12 sale language into a simple receipt for the return of deposit of, or the return of a rent security deposit on a unit as a tenant is leaving. So I will encourage the board both by making this statement. I will also put it in writing to request that we revisit 286-12 as soon as possible.
Can I add?
Yes.
Can I make a comment too? Julie, I would just add to that I think I would request that there be some type of training by Loft staff to landlords and tenants on sale of rights, because I agree that it's using this case to just make the point that I think it's confusing and often tenants and landlords don't know what is going on with sale of rights.
Okay, we'll look at it. Thank you. Is there any other comments on this case? Is there then a motion to accept this case? Mr. Barnes, is there a second? Mr. Delaney, Ms. Rivera.
Mr. Carver.
Recusal.
Mr. Bauer.
Yes.
Mr. Bruce.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shachter.
Yes.
Ms. Torres.
Yes.
Chairperson Hudson.
Yes.
7 in favor, 1 recused.
The next case is Maria Nazor and Peter Mickle at 544 West 27th Street in Manhattan. The docket number is R0357. Ms. Dudley, will you please present this?
Board members, on March 3rd, 2014, Maria Nazar and Peter Mickle filed a coverage application. On April 20th, 2017, the Loft Board issued order number 4668, which denied tenants coverage. On May 26, 2017, tenants filed a reconsideration application seeking review of order number 4668. Loft Board ruled section 1-07A2 establishes 4 grounds for which a reconsideration application may be granted. In their application, tenants alleged 3 of the 4 grounds. For the first ground, tenants argued that they were denied due process when the Loft Board applied the primary residence requirement to their coverage claims. They also alleged material fraud in the underlying proceeding. For the second and third grounds, tenants again argued that the Loft Board misapplied the primary residence standard to their coverage application, which resulted in an error of law, and that the Loft Board's determination was based on a ground not fully litigated by the parties. A review of order number 4668 shows that the Loft Board did not apply the primary residence standard in determining tenants' coverage application. The Loft Board denied their coverage claims because tenants failed to prove the eligibility criteria for coverage. In the underlying coverage application, there was no dispute that Ms. Nazar residentially occupied Unit 4N during the window period. The only outstanding issue was whether Mr. Mickle, or the principal owner of the building, or both, residentially occupied Units 4S and 5N respectively during the window period. Despite the 7-day hearing at oath, tenants failed to prove that the unit 4S or 5N or both were used for residential purposes during the window period as required by MDL Section 285, subsection 5. Specifically, tenants failed to provide credible proof that Mr. Mickle, or the principal owner, used their units for residential purposes during the window period. In its reconsideration application, tenants also failed to provide sufficient evidence proving material fraud in the underlying case. The proposed order before you today denies tenants' reconsideration application.
Thank you, Ms. Vallow. Does anyone have any comment on this? Is there then a motion to accept this case? Mr. Carver, is there a second? Mr. Barnes. Ms. Rivera?
Mr. Carver.
Yes.
Mr. Bowers.
Yes.
Mr. Roche.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
No.
Mr. Shachter.
Yes.
Ms. Torres.
No.
Chairperson Hilton.
Yes.
6 in favor, 2 against.
Thank you. The third case on the calendar is James Gugelman at 442 Broadway, Manhattan. The docket number is R0358. Mr. Clark, please present this case.
On March 7, 2011, the tenant of the third floor in the building filed an application seeking coverage pursuant to Section 2815 of the MDL. On December 9th, 2016, after the administrative judge issued the report and recommendation, the Loft Board staff received a letter from tenant requesting to reopen the administrative record to introduce additional evidence. In a letter dated December 23rd, 2016, the Loft Board staff responded to tenant's letter denying tenant's request because the Loft Board rules do not provide for reopening the administrative record after the issuance of a report and recommendation. On May 18, 2017, the Loft Board issued order number 4671 denying tenant's application. On June 23, 2017, tenant filed an application for reconsideration of the order alleging denial of due process because the Loft Board failed to make a record of the request to reopen. Pursuant to 29 RCNY Section 1-07A, the allegation of denial of due process must occur in the prior proceeding. The prior proceeding includes the entire adjudicated process up until the judge issues the report and recommendation. Since there was no denial of due process in the prior proceeding, tenant failed to meet the standard for granting reconsideration. The Loft Board staff's response letter acknowledged tenant's request, answered the request, and explained the basis for the rejection. We disagree that the inclusion of the request in the background of the order is necessary to provide a proper record. If tenant wanted to preserve his rights to the appeal, tenant should have appealed the denial of the request to reopen, but failed to do so here. For the reasons stated, the proposed order before you today denies the reconsideration application.
Thank you, Mr. Clark. Does anyone have any comment on this case? Mr. Day.
Yes, I voted against the original decision in this case. I voted against the reconsideration proposed order when it came up in July. And I've spent increasing amounts of time in this case, and it was the subject of considerable discussion in our private meeting, which I certainly won't characterize what anyone else said in the private meeting. To review, the original claim was that there were 4 residential units in this building. One of them, I think, was rather conclusively demonstrated to be a showroom that was not residentially occupied during the window period that's necessary for 281.5. The original, the report and recommendation coming from the oath judge in this case acknowledges Mr. Gubelman's use of the 3rd floor as a residential unit and finds one of the units on the 4th floor, finds both units on the 4th floor. 2 units on the 4th floor, there are 3, one's the showroom, the other 2 were residentially occupied, but an issue has come up with regard to the what I consider to be the exclusionary provisions in 281.5, which is the portion of the Loft Law which added coverage to buildings in the 2008-2009 window period. The question then turns on whether or not one unit has legally windows that can be considered legal windows that would allow it to register for coverage. And the history of this case is that it came to the board once, but was not voted on with the recommendation that the building become an intramultiple dwelling. It was restudied and came back with the finding that because one unit lacks windows, it can't qualify for the count of residential units necessary, the 3 units necessary to become, to meet the requisite number for a intramultiple dwelling, other than the whole Chelsea business that we'll leave aside. I think, and therefore, what this hinges on in my mind is Rule 208, Section D1, which discusses the calculation of residential units. And the base statement, the first statement of D1 is for purposes of counting residential units to determine whether a building qualifies for coverage as an IMD, it must be registered. Each unit must meet the criteria set forth in MDL 281 and these rules. I believe that the board this was set forth, was referring to the gross qualification factors of residential use during the window period, the building lacking a residential certificate of occupancy, and a history of prior commercial use. The way the board is interpreting 208D1, I think, is incorrect in that the fact that a unit might not qualify under 281.5 because it lacks a window, or it's in a basement, which is allowed for all kinds of other dwellings in New York City, sets up a situation where it perpetuates allowing owners to have multiple units used residentially that won't, under this interpretation, apply to that count of 3 because they can't qualify individually. I think they should nevertheless be counted to meet the threshold to determine the units that do are an interim multiple dwelling. I hope that this case does lead to an Article 78 if the board adopts the denial of reconsideration that's before it, because I think the board's holding here is in conflict with the remedial intent of the statute, and therefore I'll be voting no.
Are there any other comments on this case? Anyone else? So then, thank you, Mr. Parker. Is there a motion to accept? Mr. Carver? Is there a second? Mr. Hernandez? Ms. Rivera, could you please poll the board members?
Mr. Carver?
Yes.
Mr. Barrett?
No.
Mr. Roach?
No.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Shachter?
Yes.
Ms. Torres?
No.
Chairperson Hudson?
Yes.
4 and 4 against and 5 in favor.
What?
7. 4. 4 against.
4 and 4.
Sorry.
4 in favor, 4 against?
Yes.
Thank you. Motion is passed.
What's the decision on this?
There is no decision. It was 4 to 4.
4 to 4.
Yeah.
Yeah, okay.
We need another board member.
Okay, we will move to the next case. This is case number 4. HLP Realty Corp., and that's 238 Melrose Street in Brooklyn. The docket number is R0363, and Mr. Clark again represents. Oh, I'm sorry. It's not Mr. Clark. Mr. Bob.
Close. Thank you. In their reconsideration application, owner applicant seeks reconsideration of Loft Board Order Number 4731, in which the Loft Board rejected the November 27, 2017 stipulation as against public policy because it allowed the tenants to remain and continue to use their units for residential purposes without Article 7C protection. Owner argues that the Loft Board committed an error of law by rejecting the stipulation as against public policy because the tenants were allowed to remain in possession of their units for less than a year. Owner alleges that the Loft Board did not take into account the costs and lengthiness of the potential litigation and the amount of time it would take for tenants to vacate their units. Owner further claims that the Loft Board's public policy goals will actually be better achieved by accepting the terms of the stipulation rather than rejecting them because tenants will spend less time in an illegal occupation. MDL 301 prohibits the occupancy of a building in whole or in part until the issuance of a residential C of O. The MDL does not exempt residential occupancies intended to last for less than a year. The law is a blanket prohibition against residential use without a C of O. The only relevant exception is Section 283 of the MDL, which permits residential use if the building is covered as an IMD pursuant to Article 7C. The 2017 stipulation permits the tenants to residentially occupy their units until a future date without a residential C of O or without Article 7C protection. Such residential occupancy is illegal and is prohibited by MDL 301. For these reasons, the proposed order before you denies owner's reconsideration. reconsideration application.
Thank you, Mr. Powell. Are there any questions or comments on this case? Excuse me, are there any comments? No, then is there a motion then to accept this case?
Motion.
Mr. Rowe, second. Mr. Hernandez. Ms. Rivera, could you please poll the board members?
Mr. Carver,
Yes.
Mr. Roberts,
Yes.
Mr. Rowe,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Mr. Schechter,
Yes.
Ms. Torres,
Yes.
Chairperson Henson,
Yeah.
8 in favor.
Thank you, Ms. Rivera. There are 5 cases on the summer calendar. They are voted on as a group. The cases are Macy.
Mr. Chairman, I would ask that case number 7 be taken up separately.
There are 5 cases on the summer calendar. They're voted on as a group except for case 7, which will be voted on separately. So the following 4 cases are going to be voted on as a group. Macy Connolly and Natalino Caminha, 304 8th Avenue, Manhattan, docket number P00055. Then Quinn Luke and Lisa Levine, 100 Freeman Street in Brooklyn, P00057. Then Macy Connolly and Natalino Caminha, 304 8th Avenue, Manhattan, docket number TR1340. And Quinn Luke and Lisa Levine, 100 Freeman Street, Brooklyn, TR1343. Does anyone have any comment on this case? These cases? There are no comments, then is there a motion then to accept these cases? Mr. Carver. Second, Mr. Hernandez. Ms. Rivera, please.
Mr. Carver,
Yes.
Mr. Roberts,
Yes.
Mr. Bruce,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Mr. Schechter,
Yes.
Ms. Torres,
Yes.
Chairperson Henson,
Yes.
8 in favor.
Thank you. The next case being voted on separately on the summer calendar is tenants of 50-17 5th Street. And the address is 50-17 5th Street in Queens, the docket number TR1291. Does anyone have any comment on this case?
Yes, I appreciate you taking this up separately on the agenda. I plan to vote no on this case. The basic circumstance here is that it seems to be the case frequently. Tenants apply for coverage, landlord opposes it. At some point there's a settlement, landlord agrees to register the building, including the protected occupants, subject to a stipulation, part of which requires the tenants to withdraw their application with prejudice. This is a case like many others we've had over the last decade where there's a sentence basically that reads, the Loft Board neither accepts nor rejects the remaining terms of the stipulation. Sometimes there are stipulations that are so onerous that the board rejects them as contrary to public policy, which was the case in HLP Realty 238 Melrose Street, which we looked at earlier today. In this case, the fourth and final point in the stipulation is that the tenants waive any non-compliance with owner's obligations pursuant to MDL 284, provided the owner timely registers the units pursuant to the stipulation and timely seeks an extension of the code compliance deadline, et cetera, et cetera. Now, on the face of it, having the tenants agree to waive enforcing the code compliance deadlines may not seem like a big thing, but we're in a gray area here where over the years I've seen cases where the Loft Board neither accepts nor rejects the other terms of the stipulation, where, as in this case, the terms are relatively, the condition is relatively minor. In other cases, more and more stuff gets waived. And in some cases, as I said, we deem that it goes so far that it's contrary to public policy. I don't think the Loft Board or the ALJs at oath should be in the business of structuring stipulations that do anything that's contrary to the loft law. Therefore, I've made it a consistent practice to vote against all such cases because I don't think we should be in the business. It puts extra pressure on tenants. I think it runs up additional legal costs, and that's why I'm voting no. It's fine with me if this passes. I'm voting no to make a statement. Thank you.
Thank you. Thank you, Mr. Delaney. Any other comment on this case?
Yeah, I think the STIP is actually not contrary to the law. In as much as in our order, the board preserves all of the board's rights. I agree with you that ultimately it should be passed.
Can I ask a question?
Sure.
I'm just wondering from the staff, like how often does this happen? It does seem to take up time, no?
We don't answer questions.
Oh, you can't.
Questions are in private session.
Oh, only private, okay. Well, I thank you for making a statement because I feel that that this sets some kind of precedent that I don't agree with as to what we should be handling here. So I just want to add that.
I think the precedent is quite good. The parties are getting along. They're agreeing to things. The tenants are agreeing to pay rent so that the work will get done. This is a very good thing. And to the extent language in the STIP waives any rights of tenants, the board itself is still retaining its own rights under the law. So there are just no problems here. In fact, failing to pass this ultimately will cause the tenant to incur a legal fee to go to court to get the result that it needs. This is kind of crazy that you're opposing a STIP that's useful for everybody.
Well, actually, I take issue with that on two counts. The tenants have succeeded in what they wanted to do, and that the units are registered. And they've been named as protected occupants. And if you believe that we don't need to worry about the rights of individuals because the state will take the right actions, then I don't believe in that. I don't think people should be required to give stuff up or waive things, even with the assurance that, oh, well, no, the loft board or the police department or any other agency, be it state, local, or federal, will come in and save the day, so you just go ahead and waive your rights. I don't think that's right.
Okay, just point out that freedom of contract is a very important basis of our law, and we should respect the wishes of parties to make agreements amongst each other. The courts certainly do. We should too.
Thank you. Is there any other comment? Then is there a motion to accept the case? Mr. Coleman, is there a second? Mr. Hernandez. Mr. Rivera, could you please pull the vote?
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Roche?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Schachter?
Yes.
Ms. Torres?
No.
Schaffhausen Henson?
Yes.
6 in favor, 2 against.
Thank you, Mr. Rivera. The master calendar, there are 6 cases on it. The last 5 cases are removal cases and will be voted on as a group after presentation and voting on the first case, which is Thomas Brigham at 72 Warren Street, Manhattan, docket number LI0046. And this is Mr. Clark, who presents.
On March 16, 2015, the occupant of the third floor unit filed an application seeking a finding that owner unreasonably interfered with the use and occupancy of the unit. Tenant first argued the owner departed significantly from the estimated time schedule for performance of the work, and that it took owner 11 months to complete the legalization work in the unit instead of 90 days. However, owner was not aware of the significant amount of additional work necessary for the unit at the time of the agreement because owner was not able to fully assess the unit until tenant vacated. Furthermore, owner completed the legalization work in tenant's unit prior to any other unit in the building. Owner did not collect rent while tenant was not in the unit and paid tenant $321 per month for alternative accommodations. Next, tenant claims that owner departed significantly from the work described in the narrative statement and legalization plan. Tenant argues owner covered the west wall in the unit with sheetrock that caused a 25 square foot reduction of usable space for his film studio. Loft board precedent states that reduction in size of a unit after legalization is not unreasonable interference where the owner provides a rational plan with minimal impact on the use of the unit. Tenant failed to establish how the reduction in space inhibited his filmmaking or show how his film studio could not be reconfigured to fit the new space or otherwise caused an unreasonable interference with the use of the unit. Finally, tenant argues the owner violated the provision of the tenant protection plan and that there were conditions that created dust and debris in the unit. However, there was no proof owner was responsible for the holes where the tenant claimed the dust and debris came from, and as soon as owner was notified of the dust, owner promptly took action and paid to have tenant's clothing cleaned. For the reasons stated, the proposed order before you today denies the application.
Thank you, Mr. Clark. Does anyone have any comment on this case? Mr. Delaney?
This was a case that was also the subject of considerable discussion in our private meeting. I think that the board's conclusion in this case is incorrect, and if adopted as currently written, would set a very dangerous precedent. Just to quickly recap the facts of the dates here, there was originally an agreement in Housing Court in the middle of March 2014 that the tenant would vacate for 90 days. There was a fire 10 days later, causing some water and other kinds of damage in the building, and particularly in the tenant's unit where the fire started. One of the counts that the tenant raises, and the three reasons that he seeks a finding of legalization interference, is an incident that happened in April of 2014 where dust and rocks came into his unit through a hole in the ceiling, I believe. And having survived both the code compliance work in my own loft and the narrative statement process, unrelated to code compliance or narrative statement, I had about 6 pounds of dust and rocks land in my unit, and that kind of thing does happen. It was, in my case, it was repairing a flue on the roof that caused a whole bunch of stuff to come loose. I do not find the tenant's application on that ground to be persuasive. However, my concern is with the overall delay in the legalization work. Back to Housing Court in June of 2014, a stipulation was signed where the tenant agreed he would leave within 30 days and the landlord agreed to complete the work within 90 days. And indeed, and there was a second narrative statement conference held in June of 2014. In July 15, 2014, the tenant vacated. It was not until October 9th that an engineer report was provided to the owner citing problems with the floor joists and the bricks in the building. It was during this period, the tenant by that time had been out almost 3 months. And it was, the architect summarized the damage and the work required in February of 2015. And in March, mid-March of 2015, the tenant filed a legalization interference claim. And there was a third narrative statement conference held later in March 2015, and it was on June 4th, 2015, that the tenant had the keys handed to him by the owner when the owner and tenant appeared in Housing Court because the tenant had sought to find the owner in contempt for having at that point taken close to 11 months before the tenant was restored to the unit. I think there is a significant difference between being out for 3 months and being out for 11 months. Having been displaced from my loft twice for short periods of time, relatively short, based on 9/11 and then a 4-alarm fire that destroyed the building next to me. what I see here is a failure to communicate by the owner with the tenant. The owner really should have done more investigative work prior to the June stipulation where the landlord said he could complete the work within 90 days. You're dealing with very old buildings, and instead, from the time the tenant vacated on July 15th, it took until October 9th for the engineer to provide a report regarding the joists and bricks. The third concern with regard to the loss of 25 square feet is something I could go either way on. In this case, it's a 5.5 inch deprivation of space that runs the entire length of the loft, apparently, because instead of treating the bricks with putting some kind of wall covering directly on them, the owner chose to fur it out with 2x4s and sheetrock. The other thing to say here is the tenant represented himself pro se at the hearing at oath, and I find the way the opinion was written by the oath administrative law judge, I got the distinct sense that the oath judge really didn't like the tenant that much, and I don't know necessarily that I would. I can't say for sure, I've never met the fellow. And there are points made that the tenant had not been paying rent, so somehow, therefore, 3 months turning into 11 months with no real communication, I do not think is acceptable, and therefore I would like to propose an amendment to the current proposed order that would, in essence, deny finding of legalization on 2 counts, find legalization interference on the 3rd count with regard to the excessive delay, because I think not doing that sets a very bad precedent for legalization work in the future. There is a fine associated with the with a finding of legalization interference. I would propose that we impose no fine on the owner, but I think it's very important to set a precedent with regard to, you can't say 3 months and have it turn out to be 11 months. If you don't know, then don't give a number or arrange to do enough testing. It's not that hard to look at a 1 square foot section of wall by removing something and seeing that there's an issue that may be of larger concern. And also, I think this is a perfect example of why we have argued in the past, or I've argued in the past, that at least the final conclusions of narrative statement conferences should be reduced to some kind of writing. And in this case, appearing pro se, the tenant claims that certain comments were made to him during the narrative statement conference. There's no way to establish whether that's true or not, but I think this is a very important case with regard to both how code compliance work is done and the timing of it.
Before I invite any other comments, I just want to ask, what is your basis for finding of reasonable interference and not imposing a fine? What is your reason?
My principal reason is that for 3 months delay to turn into 11 months included, the tenant vacated in the middle of July, and the engineering report was not served up until October 9th. So I find that it is my opinion that the landlord and his vendors, his architect and his engineer, were dilatory in moving forward and assessing the true nature of the situation here.
But not fast enough, you say?
Not fast enough, not thoughtful enough.
Any other comments?
Mr. Chairman?
Yeah.
Two actually. First off, I plan to vote no for this case, but I want to say that I'm always very proud of the work that the Loft Board staff does and very respectful of the work that our city administrative law judges do. Every once in a while, there's just a case that I personally feel I need to research and dig deeper into the weeds on to be able to be comfortable with my vote. This is one of those cases, and I plan to vote no because I would prefer to have additional time to research this.
Well, I'm sorry, are you then making a motion? There are a couple of things.
No, I'm just stating why I plan to vote no, but
Okay.
the second point I just want to make is, I think, Chuck, you had stated that the board concluded, I think you meant to say the staff concluded, because the board actually hasn't.
I should say that, to be more accurate, the staff has agreed to approve the recommendation of the administrative law judge. So it's actually the administrative law judge that I think we should...
I'm sorry, the staff doesn't agree or disagree. The staff drafts proposed orders.
Fine.
I'm going to vote yes on this thing, only because there tends to be mitigating circumstances. I had a situation.
Elliot, can I just, and you're a great believer in procedure. I am making a motion, so I'm looking for...
That's
so
not
I'm
what
looking
exactly.
I'm sorry.
Oh.
That's all right.
Well, wait.
The idea of an amendment.
No.
Yes, so
We
Mr.
gotta do
Delaney
one-
has a motion.
We have to do one thing at a time.
That's right. So could you allow the chair then to...
The chair has to make a ruling on this. We can do only one thing at a time.
So there actually, I'm hearing two things, but I first want to address Mr. Delaney's motion, and that is to which, you have to repeat it because I'm not sure which charge it is, but which instance you want to, just make a motion.
yes, I'm trying to make it as helpful as possible. My motion is that the tenants made 3 claims for legalization interference, and my motion is that we find that the tenant is correct on his first point, which is the time to complete the legalization work did cause unreasonable interference. And further find that this was an instance of legalization interference but imposed no fine. And with regard to his second point, that the landlord departed significantly from the work described when he covered the west wall with sheetrock, I'm neutral on that. I don't see any reason to consider that under the circumstances. I think it was poor communication. I think it's a failure of what should have been covered in the narrative statement conference. And the third count that the third allegation that the landlord violated the provisions of the tenant protection plan and the dust and debris, I do not believe that. My concern is only with the first. And I would further recommend not imposing any fine on the landlord.
You've heard the motion. Is there a
Have
second?
you heard on the issue or not yet? On the issue of the motion.
On the issue of the motion?
Yeah, the issue of the. So the case is on
I
the
need
agenda.
a second.
I would
before-
second the motion.
No, wait. You can't really do that. I mean, Chuck,
All
I'm
right.
sorry.
So
Chuck made a point of why he was voting no.
Right.
And then on the top of that discussion, he decided to make a motion. You can't do both. I'm
So
sorry.
can we have comments first and then?
Well, you can't do both. You
No, I
have to
didn't- I didn't say that.
either go through the process
I'm
of
sorry,
voting
let
on
me-
this
let
thing
me-
and then make a motion.
let me
But
rule
you
out-
can't start discussing the order and then in the middle discuss the order making a motion.
Mr. Delaney said that he tends to vote no, but in lieu of that, he would make a motion which is what he made. Is that, am I correct on that?
Yes, if I may, Mr. Chair. I also think, and I'd be interested in Elliot's opinion on this, I think it would be better to start with a motion and then have discussion, rather than have discussion followed by a motion
I would agree with that.
in the future.
Yeah.
Where are we now? Is there a second to that motion?
Yes.
Yes. Mr. Torres.
May we speak about the motion?
Yes, now, Mr. Carver, you're in order.
Thank you. So, we have a case on the agenda. The agenda says we need to vote on it. I think the motion to amend the draft is premature until the proposed order on the agenda fails. So those who want to amend it would vote no, but I think we owe it to the parties and to the board members to actually vote on what was proposed.
I hear you, and actually there is something else to consider because another member, Mr. Roche, has asked for time to that's what I was hearing, that you need time to look at this. So it's still correct to know if this is something that we want to put off until next time, and we can always take this whole thing up again, including motions.
Though I'm getting a little bit confused because we've moved back and forth, I intend to vote in the direction that I believe is going to allow me more time to go back on this case and review it so that I can feel comfortable with my vote. So, yes, let me clarify that.
All right.
I just wonder whether or not we can get more details about this particular case if we, I mean, my feeling is that we ought to sort of put it off, table it, in the hope that we can get a little bit more information as to, one, are there mitigating circumstances as to why the landlord took 11 months rather than 3? And secondly, was the landlord deleterious in its initial statement? And these things just happen. So whether we can get more information about this, including the fact that we have discovered that this floor came in all the way from New Zealand, is that where the new flooring came in? Well, there's hardly any way that you can get anything done in 3 months' time if you're calling to New Zealand and getting a whole bunch of floor stuff brought into the U.S. So I think there are too many unknowns here to try to make even a decision about this. So I recommend that the chair table this, pending more information.
The question is, would I withdraw the motion to allow either the chair to table or vote to table? Yes.
Thank you.
Can I add one comment?
Yeah. Oh, yes.
Okay, I would just say as a comment that I understand that there are risks with a tenant representing himself without a lawyer, but I feel that we have a responsibility to make it clear to tenants the risks of moving out of an apartment. I feel like I've seen some information in subways that tells me as a tenant not to move out ever. So I just want to make sure that that information is getting relayed to the Loft tenants. Because clearly this is...
That would be the Loft board giving advice to tenants, and we're not allowed to do that. We're supposed to be neutral.
Neutral. Well, not acknowledge that there are risks involved because as an architect, construction is always delayed. And as a typical rule, 3 months versus 11 months is a long time to be out on the street figuring out how to survive. So I feel that maybe I'm misspeaking with not advice, but just the public needs information in front of them so they can make a decision that they're not left out of their home and that their family or roommates are vulnerable in this way. Once they're out, they don't have recourse to get back in unless, and clearly because this case has many backups and thousands of pages, so.
Yes.
I want to tag on to what Ms. Torres said in support, partly, but there's also a concern that, actually Helene, I think, put it the best. The board and the staff cannot really be in a position to give advice because as the fire department representative, there is unequivocally no question that there are times where, and I'm separating now the concern of somebody not letting somebody back in, but also having people living in buildings that are going through renovations and having floors replaced, things of that nature, is not always in the safe, best interest of the people that are trying to remain in that building. So there has to be a balance there. You can't say that, oh, well, I'm going to stay living in this one room while you pull up all the floor all the way around me, and then have some sort of expectation that if there's an incident at that building, that the New York City Fire Department can find, operate in this building under normal circumstances. So actually, I again say that I think our executive director probably phrased it best. I think we have to be careful when we start giving advice, should you stay or should you go? Because certainly there is a concern that, an owner may use you leaving as a way to keep you from getting back in or whatever. But please also keep in mind there's a safety component to this that the fire department and the buildings department and housing preservation and development, for that matter, have to be concerned with, and that is, can somebody safely be living in a basement when some of this renovation is going on? So there are provisions available, yes, but I just want to get that on the record that there's also a safety concern with staying in some of these buildings.
Yeah, I would just add to that. My understanding is that it's not often the case that tenants move out. And when I say, I understand he didn't have a lawyer, so that lawyer would have been giving him advice. But in terms of how I suggested earlier for the sale of rights, a training, if there can be a training or some sheet with bullet points, maybe it's not considered advice, but just equated education so that people can make an informed decision.
Sure, information, that is.
Information.
All right, good. So I'm making a decision to table this because Mr. Delay has withdrawn his motion to amend the order, and we're going to put this off for everyone to take a closer look at the case, and we'll bring it back to next month's meeting.
Cheers.
Thank you, Mr. Clark. Okay. The removal cases are Board of Managers of 583 through 587 Broadway condominium. The address is 583 to 587 Broadway, Manhattan, and the docket number is LE0675. Then 262 Mott Street condominium. Address is 262 Mott Street in Manhattan. Docket number LE0692. 1196 Metropolitan Court at 1198 Metropolitan Avenue in Brooklyn. Docket number LE0694. And again 1196 Metropolitan Court at 1196 Metropolitan Avenue, Brooklyn, LE0695. Finally, HPG 29 2nd Avenue LLC at 29 2nd Avenue, Manhattan, LE0696. Does anyone have any comment on these cases?
Yes, just going to ask that we vote separately on number 11, please.
Does anyone else have any comment on this case? I just read these cases, and I'm going to extract number 11, which is Board of Managers. Why don't we just do that first? I'm going to vote. I'm going to name it Board of Managers at 583 to 587 Broadway condominium, 583, 587 Broadway, Manhattan, LE0675. Is there any comment? Does anyone have any comment on this case? Is there a motion then to accept this case? Mr. Delaney, is there a second? Mr. Barowitz and Ms. Rivera, could you please pull the board members?
Mr. Carver?
No.
Mr. Barnes?
What are we doing? We're doing.
You're voting on
Voting on
case
number
number 11.
What we're doing is 11.
Just
Yeah.
11.
Oh. Yes.
Mr. Roche?
Yes.
Mr. Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Mr. Shachter,
Yes.
Ms. Torres,
Yes.
Chairperson Hilton,
Yes.
7 in favor, 1 against.
Thank you, Mr. Rivera. The remaining 5 cases that I previously named, is does anyone have any comment on these cases? There are no comments, then do we have a motion to accept these cases? Mr. Hernandez, is there a second? Mr. Carver. Mr. Rivera, please.
Mr. Carver,
Yes.
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Mr. Hernandez,
Yes.
Mr. Delaney,
Yes.
Mr. Shachter,
Yes.
Ms. Torres,
Yes.
Chairperson Hilton,
Yes.
8 in favor.
Thank you, Mr. Rivera. As previously announced, we switched the order, so we're going to turn now to the Executive Director for her Executive Director report, Ms. Paulson.
Thank you. In terms of registrations, as of today, we have 21 buildings that have not registered, which is well ahead of last year when we had 42 buildings at this time. So for those of you that haven't registered, we are going to start drafting orders. We will impose fines, so please get your registrations in. In terms of revenue, during July, the Loft Board unofficially collected $731,000, and during August, the Loft Board unofficially collected almost $103,000. In terms of litigation, in July I reported on a bankruptcy case where the owner of the building filed for bankruptcy and made a motion to sell the property free and clear of all encumbrances, including Loft law compliance. The judge denied that motion. The owner has appealed. The judge, bankruptcy judge, certified the appeal to go directly to the Second Circuit Court of Appeals, bypassing an intermediate appeal. So that's kind of interesting. We don't know whether or not the Second Circuit will actually hear the appeal, but it's very interesting, actually. We also received a mandamus on Sidney Saul. It was Sidney Saul Group Limited versus New York City Loft Board and Nazer and Mickle. That was case number 2 on today's calendar. The proceeding asked us to decide the case. We did, so that's the end of that. In addition, we received 2 more mandamus cases both from 99 Sutton LLC, asking us to decide an appeal of a staff determination which was issued earlier this year. And that's all I have.
2 mandamuses on one building
Yes,
from the same party?
yes.
Mr. Carver?
I'm going to talk about the memo as,
When we get to the rules, I thought it was part of the rules.
oh, fine, yeah, sure.
Yeah. You're talking about the retroactive
Yeah,
memo?
yeah.
Yeah, because it pertains to the rules, so I thought we would do that when
That
we get
makes
to the
perfect
rules.
sense.
Okay.
My apologies.
Okay.
Thank you. Are there any questions, any further questions for Ms. Paulson? Thank you, Ms. Paulson. We
I
have
have one question on the
Yes.
agenda. The expectation, in October, we're having 2 meetings.
Yes.
Is the expectation that the presentation for Chief Spatafor will be at
The 20th, October 20th.
Yeah.
I thought it was October.
Oh, I'm sorry, October 18th, yes. Yeah.
Thank you.
Okay, Ms. She had, if you recall, I think it was July. July, she did part 1, and she's going to follow through now with part 2 of the enforcement plan overview. Please.
Thank you, Chairperson Hilton. So as you mentioned, I previously gave a presentation in July, just basically giving you like the nuts and bolts of what enforcement measures are allowed in the rules. And just to remind you of the overarching objective of the enforcement plan is to induce compliance with the legalization requirements of the Loft law and encourage overall compliance with the Loft Board rules. So at the previous meeting, I advised that the second part of the enforcement presentation would focus on proposed strategies that we came up with to essentially roll out some of the measures that I laid out previously. And just a quick recap, The tools and measures that I initially laid out the last meeting were cooperative measures and punitive measures, which goes along with the reasonable necessary action that's laid out in the rules. And on your little one-page memo, you'll see that 3 cooperative measures that were listed were the enforcement and information and warning letters, which basically it's self-explanatory that depending on which legalization category you're in, we'll send a letter advising you what your status is and potentially that you may be subject to a notice of violation or a fine. Owners information sessions, that was actually a suggestion by board members Horace Moskowitz, which would be just a general information session to give owners and of course anyone else to be welcome about the layout of the legalization process. And then lastly, the legalization conferences, and what we envision would be targeting specific buildings that we think are stagnant for whatever, for reasons that we'll be figuring out, and just meet with the owners, the design professionals, whoever else the owner believes needs to participate, to kind of sit down and figure out what we can do, what guidance we can provide to move them forward. And then again, for the punitive measures, excuse me, the rules, specifically section 2-01.1 lists inspections and hearings. This is more of the punitive measures where fines can be issued upon the executive director sending out our Loft board inspector, who's actually on loan from the HPD. And from there, the report would be issued, and the executive director or staff would decide whether or not more proceedings or a violation should be issued. And again, the missed deadline violation laid out in the rules, it just basically lays out certain timeframes that owners must keep, TCOs, renewing it, application deadlines, things like that. And that is more like a specific timeframe. So if you miss the deadline, staff can essentially issue a notice of violation, and then that can, depending on if there is a violation, then a fine will be imposed. And then the specific performance measures. So I just wanted to quickly recap what the measures were. So in terms of implementation, as I listed, these are the categories that we feel that when implementing the enforcement measures we should focus on. And again, the A buildings is the beginning of the process, the beginning of the race, and E1 is towards the end, which shows E1 is the buildings with certificate of occupancies without a pending removal application. So there is an E2, just so you know, those are the buildings which essentially have the final CFO, but have a removal application pending with us. So they're pretty much on their way out. So as you can see, we're focusing on buildings, the A buildings, which is a no alteration application filed. The B1 buildings, which is they have filed an alteration 1. B3, Loft for certification. C buildings, they're all 1 permits, and then D1, D2, these are the 7B compliance folks, and as well as TCO holders. So in trying to figure out what buildings we should target initially, we kind of figure different factors to determine how engaged, or try to figure out why the buildings are stagnant, why they're not progressing towards the legalization. So we came with just a few factors to consider when selecting these different buildings in the different categories. So one, of course, is the length of time. When did they register with the Loft board? How long have they been with us? Also the status of their permits, their certificates, their TCOs, things like that. Are they active? Are they not active? We're just trying to get a sense of how involved they are in the process. Then we would also look at recent filings with TOB. Have they been, filing other permits or filings to do other work in the building? Again, just trying to gauge their level of engagement. And also, like I mentioned, overall engagement in the process. So one thing we could look at are the monthly reports. Are they submitting monthly reports when they're supposed to, if they are required to do so? And then again, any other factors that we think is necessary, because buildings can be stagnant for different reasons while they're not progressing, so we want to make sure we take certain things into consideration before we start including them in the new rollout of the buildings that we would use the measurements for. So in terms of the actual enforcement measures, these are the measures that I laid out. These are the buildings we think would be good to start the specific measures for. So in terms of the cooperative measures like sending out information and warning letters. We thought to look at the 7B compliance folks, which is the D1 buildings, and then also the D2, which are the TCO holders, and then also the E buildings. So again, the ones with the C of O but no removal application. I mean, they're pretty much at the tail end of the race. We're just hoping that, you know, a letter or you know, a warning letter would kind of push them in the right direction to get them towards the end of the process. And also for legalization conferences, we would focus on the C buildings. Now, this C building section, these are the ones with the all-one permits. It's the largest group. That's where we have over, I think, like 135 buildings, if I'm correct. That's kind of in that milestone. So to really have a success in terms of enforcement and inducing legalization completion, we have to break down this group into smaller categories. So we thought in terms of conferences, focus on the buildings who currently have active permits. Essentially, they're still, you know, doing what they're supposed to do by maintaining their O1 permit. So we thought just kind of meet with them to figure out what is stalling you, what do you need to help you move forward. Now, in terms of the punitive measures, the breakdown is for the inspection and hearings. This would be for the C buildings, but who have all one permits that have been expired. Again, we would still also look at the other factors that I laid out to determine which buildings would be right to start this measure for, but we were really focused on them. And then just determine how engaged they are in the process. And so for the missed deadlines, because this enforcement tool is a little easier, it's just based upon, you know, missing deadlines, not filing an application for this day, not maintaining your permits, that we can essentially use this measure pretty frequently for the different buildings. So that's why we have the A1 buildings, the no alteration one file people. These are people in the beginning of the process. So of course, we would look inside the group itself to figure out who's old, who's been with the Loft Board for a while, and who's relatively new. So of course, the new people in the all one bucket or category would not be targeted essentially. But we do feel like we want to start engaging owners in the process early. We don't want to let them lag early on. We want to start, you know, kind of giving a nice nudge in the beginning. And also for the missed deadline approach would be the B3 buildings. These are the buildings with the Loft Board certification. And again, that's basically says that you finished the narrative statement process. That's what the certification says. And now please, you know, move on with the work and the followings you need to do. So we thought that would be a good measure to hit them with potential notice of violation. And then lastly, the C buildings. Again, these are expired alteration one permit holders. So this is another measure. We feel that the inspection and hearing avenue may be too lengthy and we're not yielding the results that we want to yield, that maybe we can try this measure. I mean, so essentially everything that's laid out, it's not cookie cutter. You can mix and match depending on the characteristics or the overall level of engagement for each building owner in the different categories. So, but we thought that this is a good suggestion to start with, and of course we're always looking for board feedback. And lastly, the specific performance measure. I know I laid out basically, you know, what that entails, but we have had discussions with the law department in terms of, you know, what's possible. So we're still exploring options in terms of commencing these specific performance cases.
Thank you. Are there any questions for?
Yeah, I have a few. So is the intent for one person on staff to actually manage a particular property in this process that you're proposing? In terms of, would it be the same person dealing with the owner?
I'm not exactly sure what you're asking, but in
Well,
terms of commencing enforcement or
in terms of
conferences or?
warning letters, and I imagine if you're sending a letter, you're expecting someone to respond. So it seems for the non-punitive measures, would there be just one person managing the
It'll
process?
be me. It'll be Mr.
It'll be me.
Because there are like 20, I think if you say there are 3 from each category,
They would be
that's going to be 20 properties.
Yes.
Okay, it seems like a...
An undertaking, yeah, but.
She'll have support, she'll have
Yeah.
support from the other attorneys, but it's her primary responsibility.
And then that's why we kind of try to, in terms of cherry pick, so to speak, which buildings should be in the first stage of this enforcement rollout. So that's why we're kind of sticking with 3 buildings for right now.
Okay. And in the normal course of your workday, are you working on cases also, like the cases
Yes.
that we see? Yeah.
Yes.
Yeah.
And
We need to talk.
side management.
I'm sorry?
Are you getting at something else? Or?
No, it's just that last month I mentioned that, we have this pipeline of cases that parties bring mandamus lawsuits, and just by coincidence, I guess, you just announced that this month we've got 3 or 4 mandamus.
And let me just say that one of those decisions was drafted by Ms. Lavelle, who at the same time was working on the enforcement plan.
Yeah, but of course,
I mean, if you can make a case that helps the management budget for it on the attorney's line, great first.
well, I'm saying that the cases are mandatory, and this is somewhat optional. I think this is smart in terms of trying to pick the right properties where we'll get the most bang for our buck, so to speak. But I just continue to be concerned about the pace of the cases.
Well,
This is a long-standing problem. I know it existed long before you got here, but as you're taking resources away from it, it just made it worse.
We will keep an eye on it.
Yeah, I know.
Yes, Mr. Shaw.
One of the things that I was wondering about was whether there may be in some of these properties, whether you may have enough information to know about risks, health and safety risks associated that are sort of more significant than others, but for which either they've sort of been, on the one hand, you know it, on the other hand, so it's far enough along in the process to have that information. On the other hand, it's been sitting long enough that you know that, or you have some sense that they're not being addressed. They're not, and in particular, perhaps if there's expired, either permits have not been filed or the permits that have been filed have expired, and so therefore presumably the issues have not been addressed.
And I would just say, in terms of doing the enforcement plan, the benefit is, although it's a lot of front-load work, we have a snapshot of where the buildings are, and not just numbers, but the actual buildings, where each building is. And it forced us to kind of look through all our documents, look through all our systems and bids to see what's actually going on with the buildings we have no contact with. So once we have this database or our information management system in place, it's not going to be that difficult to kind of keep up. One way to find out if there are any issues are when our inspector does any inspections or any complaints we have in terms of violation of housing maintenance. That's always a big way to find out. And also, as attorneys, we are still on the front line. We still get calls. We still talk to members of the public. So we do have, to some extent, an idea of what's going on in the buildings. But having this Excel spreadsheet, which my understanding is that you all can have access to if you desire, so you can see what we found out in terms of where the buildings are, has been helpful. And it won't be that difficult to keep it updated if we have a system in place.
We have that Excel chart, or is there another one coming? Like, that's the one?
Yeah.
So I think I have it, and it's really helpful. You should have it too, because
Right.
it's...
I guess that what I'm suggesting is that be the focal point for obviously your slim resources as you're juggling cases and enforcement, that those be the priority for there might be, there might be among this population, that would be the ones that I would suggest focusing on for enforcement.
And first, we were always looking for more feedback in terms of how we should initially start implementing.
Do we have any idea as to why, maybe anyone else have any idea as to why we would have any appreciable amount of buildings with CFOs and removal applications?
So I can at least give you that quick breakdown. So we have in just the TCO category, a CFO, I'm sorry, CFO is what you said. Okay, so in terms of the two different breakdowns, we have with removals, pending, without. So without removal, pending, CFOs, we have about 11 buildings. And then we have about 28 roughly that have the CFO with the removal application pending. So, and then they are progressing in the right direction. And that number, having 11 without the removal pending is something that in terms of enforcement, just send out a letter, which is what we suggested, to let them know that, hey, this is what you need to do. And if not, we will, I believe that we've agreed to initiate off-board removals for those who have not responded.
Okay, thank you.
Just two questions. With regard to the spreadsheet, that should be updated routinely, I would think.
Yes, it's one of the duties, and also other staff members that have assisted with updating the information. So we do try to update it as best we can, but it is Excel, so just be mindful it's not automatic.
So then presumably what you folks have now is more up to date than the one that was sent to the members several months ago.
Yes.
Right. So for it to be a useful document for us, it should be circulated every couple of months.
Oh, so you want the actual spreadsheet?
Yeah, I think so.
Okay, quarterly? Is that okay?
Sure.
Okay.
Why don't we make it a part of the quarterly report?
We can do it quarterly.
What quarterly?
We can do it quarterly.
Well, quarterly as part of her report.
The quarterly report. Okay, and my other question, sometime earlier this year, I forget which meeting exactly it was, we had the presentation of the mapping project. How's that working?
Okay, so let me just say this. So we're actually in the process of redesigning the Loft Board's website, and so that's going to be a part of that whole redesign. And so it's kind of counterproductive. In fact, also the staff member that was involved in it is no longer, but that doesn't change anything. The data is still there. So we don't want to put that stuff up on the old website. So the Loft Board will be getting a new website short.
So in the interim, if I wanted to come in, is there something I could look at if I came in?
Yes.
Sure, absolutely.
Okay.
Yes. And I will say that I have actually been updating the maps to the extent that I can. I had one glitch that I couldn't solve, but other than that, as things have been changing, I actually have been updating them so that when it is put on the new website, it will be hopefully accurate.
Your building is certainly on it.
It should be off. No, it should be off.
See, that was a
It is off.
Okay.
Yeah, it was not when it should have been, but now it should be.
We were anticipating.
Yeah, here we are.
Thank you. Thank you very much, Mr. Good job. All right, I just want to take a 1 or 2 minute break. We're back in the record. We're going to discuss rules in the interest of time and at the request of some of the board members who really do have to go. We're going to do our rule discussion now for the next 15 minutes, so we'll try to close out as close as possible as close to 4 as possible. So, what's your name again? Miss Lawson.
So I wanted to start the discussion today with the memo. The board had asked about whether or not rules could be retroactive, and we had one of our summer interns, Trishawn Raffington, do the research, and she actually wrote a very nice memo giving an overview of the cases basically saying that there's a Supreme Court case that seems to say no, but there are federal and state cases that seem to say yes. So I think it's up to the board what it wants to do. So to the extent that you want to talk about it.
Yeah, I just had some questions. So I think at the moment, I think none of the rules right now, the proposed changes, are intended to be retroactive. Is that correct?
That's correct.
Okay. Now, on the issue of the memo, by the way, this is so well done that
She do a great
I
job.
hope you actually hire her when she graduates. It's really nice. There was very little New York authority. There was one appellate division case and then one lower court case. I was just concerned that we weren't necessarily getting the full or right answer without a higher level case. Is that just a consequence of this issue not having gone up there?
Correct.
It is?
Yeah.
Okay.
She did very extensive research.
Yeah.
So if there had been a Court of Appeals case, she would have found it.
Right. And also, absent from the memo is, are there any other areas of law that would also impact the conclusion? So is there some line of constitutional cases that would actually impair her analysis?
Actually, I think she did touch on that. I don't remember exactly where,
Okay.
or maybe in reporting one of the cases, but one of the factors that's considered in determining retroactivity and whether or not to apply it is whether or not parties have relied on certain
Yeah, I was thinking of that.
rules as they were at the time that the proceeding was commenced. So that it's in there somewhere. I don't remember
All right.
exactly where, but that is definitely a concern and something for the board to consider.
Okay, I just wanted to make sure that we were hitting all the bases. All right, well, thank you very much for this. This is really helpful.
Is this considered a public document?
Yes.
Thank you.
I guess.
Well, I'm thinking that this is...
I mean, we're talking about it here, so
You know, it's a document from
I
the
guess-
lawyers to the...
technically it's attorney work product,
Yeah.
but I mean, it's just an overview of the cases. It's really not,
Informational thing, right?
Yeah.
It's not any kind of...
it's not an
Secret
opinion.
strategy, no.
No, I mean, it's not, she's not giving an opinion. She's saying, here's the state of the law. So if there was an opinion, maybe I would feel differently.
Okay, I think we have time also to start.
Yeah, so I don't know that we need to make any decisions today, but it's something for the board to think about when we finally get to the point.
In terms of retroactivity?
Yeah.
Well, I think, I don't know what's out there that's currently being, dealt with at oath, for example. I know
One of the proposals that we've discussed with regard to changing the burden of proof on incompatible use, obviously there would be a question if we adopted that, how that would apply to cases that are in the pipeline. I could see that generating considerable controversy, given that at the moment no new applications are being accepted. I guess this would, if we decide nothing is retroactive, then these would all be in place when the curtain comes up, if the curtain ever comes up. And we open the window and start accepting new applications.
I would agree. Mr. Walsh, yeah?
Colleen, after reading this document, I respect your opinion greatly. Do you have any thoughts other than what we've already discussed or anything?
I mean, I think, there's precedent out there that would support it if the board wanted to go and to say that some of the rules are retroactive, but I think it's dangerous. And you could wind up with a whole bunch of people relying on a rule that's supposed to be retroactive, and it goes to court, and then it's overturned. So I don't know. I mean, could we do it? Yeah. Is it risky? Yeah, it has a lot of risk. So I think it's something that the board really needs to think about.
Thank you.
And do you have an opinion about this?
Well, I think
That's my opinion, is it's risky. My opinion is you could do it based on the precedent, but it's very risky. So that's my opinion.
Okay.
But, you want my opinion?
Yeah, go ahead.
Well, I've always heard rules are prospective, not retroactive.
Yeah.
And wasn't there some Supreme Court thing that basically said no?
Is the Supreme Court case, the first case that's discussed in the memo is the Supreme Court case where and Supreme Court as in United States Supreme Court, not New York Supreme Court, where the Supreme Court said that the enabling legislation for the agency that's passing the rules would have to provide for the agency to make retroactive rules. That's what the Supreme Court case said. However, despite that, there seem to be lines of cases where agencies are doing it anyway. So, could be that nobody sought to challenge it up further. I don't know. So that's why I think it's risky. So, it's just something to think about.
Very risky thing.
So we can get away with this as long as some lawyer doesn't challenge it somewhere down the line.
Which I think is
And
unlikely.
it seems to me, from just reading some lawyers today, that we probably would get challenged. Because they seem to challenge everything.
Can I just say that it's, lawyers are representing clients? It's not the lawyers, it's the clients, they're...
they're
I just want to say,
Are you saying they're challenging
I
clients?
just want to say, defending my profession. Okay.
If all you have is a hammer, everything's a nail,
I
right?
mean, some of my best friends.
It's so architects.
Okay, so-
Surrounded with lawyers and like that.
Okay, so in terms of extensions, I did send everybody the draft more than two weeks before. One thing that I would want to point out, because I included something that the board had sort of touched on tangentially, but hadn't really come to a consensus on. So on page 3, I added in, and I'm not married to any of this language, but there had been a discussion about, do they have to have a specific date that they need, or should it be a reasonable amount of time, or whatever. So I added in a concept of an owner getting some sort of time estimate from an architect or professional engineer to include with their application for an extension. Now, I understand that presents problems for owners because they may not necessarily have access to all of the units, and that's a hard thing to do, but I just wanted to put in something there kind of as a placeholder to remind the board that, there were differing views on both sides, and so that was a suggested compromise, but it's something that wasn't there before and that we hadn't discussed in advance, so I wanted to point that out to you. The rest of it was pretty much, I think, everything that we had discussed in terms of making prospective changes to the rules. So I guess if anybody has questions.
I had a few issues. So on the issue of the architect kind of saying what the time frame would be, that was a very interesting proposal, so that the time frame is coming from someone with some basis,
Yes.
as opposed to just the owner. But do you necessarily want to outsource that to someone else? In other words, should you ultimately have control? I don't recall if it shall or that you shall adopt the time period or may.
May.
Oh, it's May,
It should
okay.
be May. If it's not, I wanted it to be May.
Yeah, I think you should still have some like oversight of what you can pull from one of the experts. Second issue just is at the very top of page 1. You'd be giving owners 30 days from the effective date of the rule to make their application for those who are currently out of compliance.
Correct.
And that's somewhat of a short time period if you don't have notice that the rules are about to take effect. Would there be some way of keeping the bar apprised of where the adoption of the rules is in the pipeline? Because if someone has to have an architect give a time frame,
Right.
it seems like just having 30 days without any notice, that might be hard to do. So one solution would be to make this period longer. The other is to have some ability to talk to the owner's attorneys to let them know when the gun is going to go off, to start your sprint, so to speak.
So I will say that the city has a website, it's New York City Rules, and all of the proposed rules and past rules, comment periods, all of the information about rulemaking is on New York City Rules. The agencies who are doing rulemaking are required to submit documents, the proposed rules, the final rules. Those are all we're required, any agency that's doing rulemaking is required to submit it there to be posted, as well as publishing in the city record. So it's in addition to the city record. So that's one thing. We could put it on the website, certainly, to say, the board has passed rules, assuming that we ever get there, that the board has passed a rule and it's going to be effective whatever date. And we actually are required to put the copies of the rules on our website as well. So are you talking about something more than that? And if so, what form would you like that to take?
Right. Well, I just don't personally know about the process, but it's possible that not every agency's rules take the same amount of time at each stage of the pipeline, or am I wrong about that?
Well, basically what would happen here is that the board would adopt a final rule. We would publish that in the city record and post it to New York City Rules, and the rule becomes effective 30 days after that. Then the owners, once the effective date comes into effect, would have another 30 days based on this rule. So really, if they're in the loop and following what's going on, they would theoretically have 30 days, because it would be 30 days from when the rule is published in the city record until it's effective. 30 days, right. 30 days from when it's published, it becomes effective. The final rule becomes effective, and then they would have another 30 days from that.
Okay, so this is after the comment period, all this...
Oh, this is at the very end.
After
Oh, yeah.
the law department has okayed
Everything, yes.
Okay, I was concerned that we wouldn't know that...
No. This is at the end, all the way at the end.
Right.
Following up on that point, your point's well taken. If all of a sudden you've got 300 owners who are owners of registered IMDs, all of whom think they have a reasonable ground to apply for an extension, trying to get the experts to provide the documentation in 30 days would be kind of like a gold rush. But given that it's the case that the Loft bar is pretty small on both sides, I would think it's part of your job and the job of learned counsel to kind of bring their owners up to
be aware that this might be coming down the pike. The other question, in state legislation, there are times that the act takes effect immediately. There are times that the act takes effect 180 days from the signing. Is the city, and I know in city rulemaking, it can take effect right away if the mayor or somebody makes a declaration of emergency, statement of need. But is there a similar mechanism where it could take effect in 60 days rather than 30 days?
Yeah, we could do that.
Okay.
You could always make it longer.
You can make it
There's a
longer.
minimum. But
30 is
you
not,
can make it longer.
30 is not fixed, okay.
I'm just trying to make this work. In other words, once we're going to do, if we decide to do this, it should be something that we're going to try to make work as opposed to squeeze it so that some worthy applicants won't fit in.
Yeah, no, I understand what you're saying. Again, I threw that out there.
Can you tell me what the application is? So they get 30 days, there's an application. How simple is that to fill out, that application versus
I mean,
needing an architect?
typically, the way that it works now is that it's an application form, and they attach various documents to it to document the compliance with the statutory standards, so that the situation was beyond their control and that they made good faith efforts. So, you know, there's usually an affidavit, there's supporting documentation. Here, if the rule goes through the way that I contemplated it or the way that I proposed, they would also need a statement from an architect. A lot of them already submit statements from architects, not everybody, but a lot of them do. So, you know, it's hard for me not being on that side of the coin to know how long it takes. I would assume for some people who are very together, it's a relatively short period of time.
Just unhire that engineer from Warren Street.
I'm
The
sorry.
engineer from Warren Street.
Oh, yeah, well, that's Jim.
Um,
Yeah, that's a good point.
But as we reviewed in July, we tightened up the extension provision considerably from the way it was in the freewheeling 90s. Now we're going to loosen it a little bit. We're not, as I understand it, changing the grounds for which an extension will be granted.
Absolutely not.
Which is still fairly minimal, but I agree that if we give a 30-day grace period, that anybody with a worthy claim should be able to amass that. Hopefully they won't be crowded out by people who are taking a pie-in-the-sky shot, hoping for it without really having really good grounds. I'd like to just get a couple other pieces of this. Can we move on from that?
Yeah, I had some other thoughts, but I'm happy to come back to mine as we talk about yours first. That's absolutely fine.
And I just thought of one more thing
Sure.
along those lines. I just wanted to get the information out so people know that now. I mean, they're all on a track to get a C of O. Some of them have stalled, right? So if there was awareness that this is potentially going to be voted on, they could prepare for it happening. I mean, they're supposed to be preparing anyway, right?
Yes, I mean, certainly for the people that are actively, I think for the owners that are actively pursuing legalization, that are out of compliance for legitimate reasons, it should be relatively simple for them because they're doing it anyway. They have an architect, they're working. So I think for them, it would be relatively simple. For the ones that are stalled, I think it would be hard.
My question was going to be, on page 3, it states that the owner responsible party must serve a copy of the application on the occupant of each IMD unit. That would mean that the residential occupants are affected parties.
Yes.
They're affected parties. What about commercial and manufacturing tenants?
I think this is just a rephrasing of what's already there. If you look at what's in blue above, that was
Right.
crossed out.
Right.
So that's just, I just made it active. I used the active voice instead of the passive voice. So I just reconfigured what was there. If you want to add the commercial and manufacturing units, you certainly could. I don't know why they would be concerned as to whether or not the owner has a code compliance extension to legalize the residential portions of the building. But perhaps they would, or maybe.
I'm going to give it some thought. I just wanted to
Okay.
understand the first time I'm seeing it.
Yeah.
And on page 4, the executive director will promptly decide the first extension application. If the same owner, same building files a second application after the first, the executive director will promptly decide the second application. The board will decide on the additional applications for extensions filed by the same owner for the same. So I know we're currently allowing someone, if I've missed all 4 deadlines, I can file one application that applies to all 4.
Yeah, that's actually how everybody does it now. That isn't actually how the rule's drafted, but
Well,
that's
my
how
question is,
everybody
how
does
would
it.
we do this going forward?
So I would envision that they would be still applying for extensions of the same deadlines, but like, let's say they were given, I don't know, until February 15th to get a permit. And they didn't get it by February 15th, but they're probably going to be able to get it by March 15th, so they could apply for an extension of that one deadline to kind of move it. The ultimate amount of time stays the same, but within the timeframes, they could move around and move things. So I think that's how I contemplate it working.
And if I'm the owner and I make an application for a extension of the permit and also the other deadlines.
Right.
That's one. I'm just trying to figure out when there'd ever be more than two. I think it would only be if you enforce each application has to be for just one deadline.
I don't know. I mean, we had a building where they had to get landmarks approval, so they were stalled on landmarks approval, and then once they got landmarks approval, another issue came up and they had to go to the BSA. So that would have been at least two. Does that come up all the time? No. But I don't know, I think it's a good.
I'd give that some thought.
Yeah.
And now, I'm an attorney advising tenants, for whatever reason, the tenants in this particular building, which is a registered IMD unit, are withholding rent because the code compliance timetable, they're out of conformity with the code compliance timetable. There's some debate as to whether that's a large number or not so large a number. But now the landlord has applied for an extension. So I advise my clients, you could find your owner back in compliance and you would need to start paying rent. But that would come to pass only if the extension is granted.
That's correct.
And it would be applicable at that time, not
That's
on
correct.
any kind of reach back.
Right, it's not retroactive.
Right.
Would that be as of the date of the granting of the application or the date of the filing of the application? I suppose the grant, I guess. Well, we could think about that.
We usually from the filing. Yeah, we usually do it from the filing. Yeah, we start counting, like, the law says you can have an extension of X amount of days from the effective date of the law. I forgot to get that to you. Okay, and so for the purpose of an extension application, we count the effective date of the law as the date the application's filed. That's just been our policy.
How many have comments? I have some comments. You have some. Robert, you have some comments. Are you done, Chuck?
I'm not only done, but I'm going to have to leave in a couple minutes.
Okay.
Okay, so I had some other issues. If you have commentary on topics that we're talking about now, you should go first.
It's on the body of this piece. I don't know if it's not specific to what Chuck was just saying, so you can go ahead.
Good.
Okay. On page 1I, where you propose to take out something because it was defined in chapter 1, I just want to make sure you're going to reference where it's, so that someone reading this can find it in chapter 1.
Okay. I'm not big on cross references,
Oh,
but.
or leave it in, because as I
Okay.
asked you about this, I didn't know where,
Yeah,
I wouldn't have
okay.
known to find it.
I'll answer it.
Okay. And then I also had a question further down under standards. Where was
The statutory standards?
statutory?
It's on page 2.
Right. Where it gives the reasons as landmarked building, Board of Standard and Appeals. The third reason being denial of reasonable access to an IMD unit. I thought there you could insert you were explaining to me the access application and that there's, so that whoever's reading this understands what defines that denial of reasonable access, which, could you explain it to the public, just so they?
Well, usually in a situation where an owner was going to claim that the reason that they could not, that they need the extension was a denial of reasonable access to a unit, we usually require them to have filed an access application. Or they could go to court, right, that's another choice, which we have, actually. So there has to be some objective showing that they tried to get access. It's not that they can just say, oh yeah, I asked and I didn't get access.
So we can just show the notices.
Well, I think if they showed the notices and they had an email from the attorney saying my client is not giving you access, that would be something. I mean, it depends on what the quality of proof is.
Okay.
Does that answer your question?
Right, I just wanted more clarification, because
Okay.
of the three, that seems a little vague, unless it's further clarified.
No, I mean, tenants are required to give access, and it could be that the reason that an owner couldn't go forward was because they couldn't get access, and somehow they have to prove that. One way to prove it is to go to court. Another way to prove it is to file an access application. Another way to prove it would be something from the tenant or the tenant's attorney saying, we're not giving you access. And I see those emails. I mean, we get those. So then it becomes a question of whether or not it's reasonable, and that would be a call that we would have to make.
So it could be an email, not just the access.
It could be. I mean, if you have the tenant saying, I'm not letting you in, what else would the owner have to show? I mean, whether or not it's reasonable, there could be a reason, a good reason why the tenant is not letting the owner in. I don't know, but it's going to be resolved on a case-by-case.
I guess
But
I
we
see
can
that.
take this out if you want.
Right, I'm just
They're just
concerned because
examples.
landmarks make sense because it's a process with the city, BSA is a process with the city. IMD unit not getting access, how many IMD units are in the building, how many are, if it's just one apartment, is that really, I just thought
Well,
it
it could
could
be,
be
because
clarified.
if an owner is filing an alt-1, they're supposed to have an alt-1 that's for all of the units, right? So if they can't get access to a unit, even if there's 100 apartments in the building, if they got access to 99, they still can't file the alt-1 until they have access to number 100, right?
Right. So I guess my point is just that there should be an access application, some kind of history that there's not been access, rather than the landlord saying, you won't let me in once or something. Like there has to be a record of.
Yes. And there is a requirement that they attach supporting documentation. They can't just say, I didn't get access.
Okay. I think I'm finished.
Okay, on page 4, the time limit, the maximum amount of time stated to obtain a C of O. So on page 4, little
Yeah.
4.2. I'm not sure what this means in that, is it that no extension can ever go beyond that period?
So let's say the law now gives, what is it, 30 months, right, to complete the process?
Yeah.
Right? So the board could grant extensions up to 30 months, right? And then if they've achieved 7B compliance, they could get another 2 years to get the finals.
Okay, so I was worried that if we've already passed that date now, that no one would ever benefit from this new rule. That's not, this is all, the time periods would start anew?
From when the date of the application.
Okay, I see.
Although if we get a huge influx, we might have to make some sort of an adjustment for that. If we've got 300 applications at once, we might have to think about that.
All right, so I got to think more about the
Okay.
time period. I might have some other questions at the next session.
Okay, well, the next session is, let me just make perfectly clear that next week, we are discussing protected occupancy. We're not discussing this, we are discussing protected occupancy.
With regard to that, if we get through protected occupancy,
That's fine.
would we then go on, or that's all we're going to do next week?
Honestly, do you think we'll get through it?
I don't know, but I just want to know what to prepare.
Oh, okay,
Maybe we
said-
can just agree we'll deal with
Yeah,
protected occupancy.
Yeah, I think I said protected occupancy and then a couple of other things that were like short, like amending penalties and things like that. So, in the event that the pipe dream that we get through it, we could deal with those short things. I think the extension rule is a longer discussion, so it would probably be better to come back to it. But I did attach to the packet that I sent
Right.
everybody a couple of things at the
Okay.
end, which I
So
think are
if-
not problematic.
If we make great headwind on protected occupancy, we'd look at the penalties as well.
Yeah,
And then come back to kind of look at everything
yes, because we still have some narrative statement things.
come November.
Yeah.
Okay, thank you.
Oh, and I was just gonna add that maybe we could send to everyone, you mentioned there was a milestone chart of what the estimated time in relation to
What the
this
law is.
extension, what the law is.
Yeah,
That-
yeah, we can send that out.
As we send it to everyone.
Yeah,
Meeting at 2:00.
yes, because it's rules.
This will conclude our September 20th, 2018 Loft Board meeting. Our next public meeting will be held at 280 Broadway, 3rd floor conference room on September 27th, 2018 at either 12:30 or 2 o'clock. As soon as we clarify that, please, board members, please sign in and hand me attendance.